The secret to securing your ERISA disability benefits for your own occupation claim. Now, if you have a long-term disability policy through your employer, it's most likely governed by ERISA. And if your doctor is telling you to stop work due to your health, there's a crucial step that you should take before you stop work and apply for your benefits. What is it? Well, you should be reading your policy cover to cover. You need to understand what the benefits are that you'll be eligible for. Many times, disability policies are designed to pay benefits for up to 2 years if you're unable to perform your own occupation. And you need to understand that definition of occupation in the policy or the plan. But here's where it gets tricky. After 2 years, that definition will normally change. Now you're required to prove that you can't do any occupation to keep receiving benefits. Now, just because your claim was approved before doesn't mean that they're going to approve your benefits when the definition of changes from an inability to do your own occupation to an inability to do any occupation. And I will tell you, the reviews get tougher. The real secret to continuing your benefits is to prove that you can't even do a sedentary job. Now, that's what the default is for disability carriers. So what is a sedentary job? A sedentary job is one that means no lifting more than 10 pounds occasionally, things like small files, small tools, ledgers, and it involves sitting about 6 hours or standing or walking no more than 2 hours in an 8-hour day. Now, that may sound simple, but for many people with serious medical conditions, even that is too much. So around the 2-year policy limitation change, if you will, the insurance company is going to send your file to a medical reviewer. We call them liar for hire doctors, to review the records, review your doctor's opinions, and ultimately their job on behalf of the carrier or the plan is to say you can engage in some kind of a sedentary job or work, even though your records may say something else. That's where the games begin. So what are some of the kinds of physical limitations that can prevent somebody from doing sedentary work? They are simple in my view. If you're unable to lift 10 pounds, if you can't stand or walk for 2 hours combined in a day, that's a clear limitation. If you need a walker or a cane, if you have to elevate your legs above heart level, if you have problems with bilateral manual dexterity, those are the kinds of things that can reduce a person's work capacity to less than sedentary. A couple other factors would be the need to change positions constantly or requiring rest breaks that total more than a couple hours per day. If you have going to have an issue with absenteeism, those are also ways that you can reduce your capacity to less than sedentary. And the best way to address this issue might be to undergo a functional capacity evaluation to measure your physical capabilities, how long you can sit, stand, stoop, walk, and bend. Don't let disability carriers wrongfully deny your claim at the any occupation stage. They're games that we know they play, and you can protect yourself by consulting with an experienced ERISA disability attorney about 1 year after you've been on your ERISA disability benefits. That's when the games are going to start to be played, and that's when you should start to protect yourself from a wrongful claim denial or termination. Call us today at 727-894-3188 for a complimentary consultation. We can help you regardless of where you live in the United States and regardless of who that disability carrier plan might be. 727-894-3188.